Now, Michael tells the story of inadvertent infringement, and it's got to be true. It's got to be true that, you know, the people who find themselves on the far side of the V in patent litigation are not Snively Whiplash sitting there twirling their mustaches, scheming to do harm to somebody. Okay, I totally get that. But at the same time, it also has to be true that patentees could be incentivized to knock on their door early in life and say, hey, I'm pretty sure you might be infringing my patent, and I'd like to talk about ways for you not to do that. And I understand that you're ramping up your business, and we should probably have this conversation before you finish ramping up your business, because it will work out better for both of us if we strike a deal early. And that's exactly the behavior you see happening in these patent cases, is that patentees are trying to, in fact, hold their counterparties into conversations. And rather than hold them up and stop them from getting deals done, they're trying to engage in constructive conversations. But one of the things you're seeing today is that the infringers have a very easy time giving those patentees the Heisman. There's absolutely no reason for an infringer today to actually talk to the patentee, which puts the infringer in the position where later she can credibly say, oh my gosh, now that I've spent my $2 billion to build my facility, I would be held up. You'd make me waste all of this money if I have to tear it down, and now the patentee has leverage over me. But we should remember that in every one of the high-profile cases where this comes up, in fact, the exact opposite facts were on the table. So even in the research and motion litigation, Research in Motion was approached for a $2 to $3 to $4 to $5 to $6 million settlement. Now the case ultimately settled later for $600 million. That sounds like a lot of money, and it sure is, but it's half the market estimate of the case, which was $1 billion, and it's a third of the infringer's estimate of the case, which was $1.8 billion. And it's 100 times what the infringer was offered at the beginning of the case, which was around $6 million with an M. And so when you sit back and you say to yourselves, is holdout possible? Absolutely, it's possible. But turning then to the real problems of patents, there are problems with patents. And on Monday in the Supreme Court justices asked some very hard questions about patents. And unfortunately, they didn't get the right answers. I think the right answer should have been, justices, you raise some great questions. Absolutely. It is essential that patents don't issue on stuff folks otherwise are doing. And it is essential that patents don't issue on stuff folks otherwise we're about to do. And that is exactly why the patent system has the rules of 102 and 103. And if you think we should pay more attention to those, we're ready, willing, and able to do that. And in fact, you've already told us to do that most recently in the KSR case. And by the way, justices, if you think patents are issuing in a way that isn't clear or isn't teaching the world how to make and use the invention, then golly gee, we should have an area of patent law that requires patents to do that. It just turns out we do. Those are the disclosure requirements of Section 112. And if you think we're not getting those right, well, okay, we can have a conversation about that too. But the one thing we should not do is expose ourselves to a very different set of errors, which is the willy-nilly decision-making that we see in the area of subject matter, an area that we have seen has been very susceptible to pure political influence. During the Kennedy-Johnson administration, in the lead-up to the Benson decision, under a Democratic administration, you saw pure play politics get Section 101 cases adjudicated. And during the Bush 1 administration, in the lead-up to the Allapat case, you saw the exact same thing happen. It happens under both Democrat and Republican administrations. It is an area where political whim is what drives the decision-making, and markets don't do well. They have a very hard time planning their businesses when they know that whole categories of patents can be thrown out just because of political whim. Thanks.
Okay. I will now allow each of the speakers in turn to respond to one another, and then we'll be pleased to take some questions from the audience. Daniel, please go ahead.
All right. Well, I'm not a big debater. I don't really get into that stuff, and I don't necessarily think there's ever a right or wrong answer. We all have our own impressions of what we think is right or wrong for us, or what we think is best. And our system of government is just how we relate to each other. But there were a couple things that I just wanted to respond to. And the injunction debate, although this is a meta-level discussion we're having here today, I think the injunction issue is a very good example of how the meta-level disagreement plays out. And I'm going to purport to you that no intellectual property owner, not a single one, ever wants an injunction. How do I know that's true? Because no intellectual property owner, if given the option between getting an injunction on the one hand, or every single dollar that exists in the world, on the other hand, would ever choose the injunction unless they're simply irrational and they just really don't want people to do that thing no matter how much money. We're all economically derived. So Richard is correct that the problem with my proposal about efficient infringement is that we don't yet have a sound system of coming up with a correct valuation for infringement. But I've got a solution. The solution is very simple. You have two well-represented parties, adversaries in a litigation. They each come forward with what they propose would be the correct answer for the ongoing royalty for continued infringement of the patent, and the judge chooses whichever one of the two she thinks is correct. That will drive parties to do the correct amount of investigation and analysis, drive them towards the middle instead of to polar opposites where then a judge has to split the baby. And we then have a fair resolution of whatever value that value is. And if the judge selects the value that the intellectual property owner chooses, and that makes it impossible for the infringer to continue their infringement because they can't make enough profit to pay it, then we won't have an injunction. So I still don't see how, and I do at a meta level disagree with anyone who says patents, copyrights, and trademarks are property. They are not. They are exclusive rights granted by our government, just like many other exclusive rights we have. They aren't property. There's no marginal cost to replicate them. They have many other things that make them different from real property. They are some things that are similar, but they aren't property. In fact, I don't agree with the categorical term intellectual property. I think patents, copyrights, and trademarks are each patents, copyrights, and trademarks. So, and my last point I'd just like to say to Scott, I'm fully a big believer in market negotiation. But in my case that Mark mentioned at the beginning, I represent individual women who have either had breast cancer or have a family history of breast cancer. And they want to get a genetic test, which costs a couple $100s to complete, to determine whether or not they have an 85 to 90% chance of getting breast cancer. Well, because the Patent Office, in all of its wisdom, has granted patents over genetic sequences and correlating mutations in particular genetic sequences to having an increased risk of disease, there's only one company in the country that's allowed to do that for my clients. Well, my clients are poor. They can't afford it. Or actually, one of my clients actually did afford it, paid for the test, got a yes, you have a mutation. She wants a second opinion before she goes and have her breasts removed. I think that's pretty reasonable. I think she should have the right to go in an independent lab that's not under contract from the patent holder, that's not beholden to the patent holder, and get a second opinion to make sure that they got it correct. Because, footnote, this patent holder has given incorrect yeses in the past. And so for anyone to say that that woman, my client, has market power to negotiate with these patent holders who they've written to her. I wrote a letter asking, would you please allow my client to go get a second opinion? She's already paid you your money. They said no. And that's ridiculous. And if you allow instances of that ridiculousness to exist, it threatens the entire system, because that anecdotal evidence of a few bad apples could threaten the policymakers to cast aspersions on the entire system as a whole. And that's all I suggest is we oversee reasonable behavior.
Okay.